Welcome to another insightful episode on the law and practice on criminal investigation in Nigeria, a legal education series presented by Umar Sahabo Yuguda, a seasoned legal practitioner and a commentator on criminal justice reform. In today's presentation, we delve into one of the most fundamental aspects of criminal investigations, arrest. This episode explores the meaning and legal foundation of arrest under Nigerian law, the duties of investigating officers when effecting an arrest, including compliance with legal safeguards and the right of suspects, the distinction between arrest made with or without a warrant, and the conditions under which each applies, the power of special agents and prosecutors to make arrest under specific laws, the concept of arrest in lieu of suspect, its meaning, legality, and controversy surrounding its use in Nigeria. The aim of this presentation is to educate law enforcement officers, legal professionals, students, and the general public on the proper legal framework governing arrest procedure in Nigeria. Therefore, promoting accountability and respect for human rights in the justice system. Let's now join Umar Sahabo Yuguda as he unpacks these topics and bring the law and practice of the criminal justice system in Nigeria to your doorstep.
After follow-up investigation, there is what we call arrest in the stages of criminal investigation process. An arrest is a legal action where a law enforcement agent takes a person into custody, usually because they are suspected of committing a crime. The arrest makes the formal beginning of the criminal investigation process against an individual. The arrest allows an investigator to further examine the case and gather additional information or evidence and prepare for the process ahead. Before making an arrest, police must have probable cause, a reasonable belief that a person has committed or is committing a crime. There are duties of an investigating officer when making an arrest. His first duty, an investigating officer have to establish a probable cause. An investigating officer conducting an arrest must confirm that there is a sufficient evidence or reasonable grounds to believe that the suspect committed a crime. An officer conducting an arrest needs to obtain an arrest warrant when it is required. And if the situation does not allow for warrantless arrest, the arresting officer must present evidence to a judge to obtain a warrant of arrest before arresting the suspect. The investigating officer also need to identify themselves, especially when they are not in uniform. The investigating police officer also need to inform the suspect the reason for arrest. An investigator conducting an arrest must inform the suspect why they are to be arrested by naming the name of the crime committed or showing the suspect the warrant if applicable. The investigating police officer also have a duty to use some reasonable force when necessary. An investigator may use proportionate force to carry out the arrest. However, excessive or unjustified force can lead to disciplinary action or legal consequences. The officer needs to ensure safety. An investigating police officer is expected to secure any weapon or dangerous item found in the possession of the suspect when making an arrest. They have a duty also to protect themselves, the suspects, and the bystanders when making an arrest. When arrest is conducted, an investigating police officer is expected to transport the arrested person to a detention facility and complete the booking processes by recording their personal information, documenting the time, place, and nature of the arrest, and to take their fingerprint and photograph for record purposes as the case may be. The investigating police officer also has the duty to respect the rights and dignity of the suspect. He should avoid harassment, coercing the suspects, or unnecessary physical or verbal abuse. On arrest, there is what we call arrest warrant. An arrest warrant is a court order that gives the law enforcement the authority to arrest and detain a person suspected of committing a crime. Arrest with warrant. Any individual or person who is alleged to have committed an offense may be compelled to attend court by arrest. Arrest may be with or without warrant. An arrest with warrant occurs when the law enforcement apprehend a suspect based on a formal legal document, that is the warrant, issued by a judge or magistrate. The document, that is the warrant, authorizes the police to detain the individual named in the warrant. The warrant of arrest has some certain contents. The content of warrant of arrest should contain the name of the person to be arrested, the specific crime the person is accused of committing, the signature of the issuing judge or magistrate, and the warrant must be in a duplicate copy. There are instances, as I said, when warrant of arrest can be issued. Warrant of arrest can be issued where the law that created an offense states that the offender cannot be arrested except with a warrant of arrest. Warrant of arrest can be issued when a serious offense is alleged against the offender, such as felony. Warrant of arrest also can be issued when a person disobeys a criminal summons earlier issued by the judge or the magistrate. The issuance of warrant of arrest. Arrest warrant can be issued on any day, including public holiday or Sundays, to whom warrant of arrest may be directed and the duration. By the provision of Section 38 of the Administration of Criminal Justice Act 2015, a warrant of arrest may be directed to a police officer by name or all police officers. It is not necessary to make a warrant of arrest refundable at any particular time, and a warrant of arrest shall remain in force until it is executed or until a judge or magistrate, as the case may be, cancels it. Where a warrant of arrest has been executed and the suspect arrested has been released on bail, the warrant of arrest shall no longer be valid authority for arresting the suspect. Once a warrant of arrest is executed, it loses its life immediately and the subsequent execution was irregular and unlawful. Execution of warrant of arrest. The general rule is that warrant of arrest can be executed anywhere and at any time. However, the warrant of arrest cannot be executed in some places, such as court, while the court is in sitting. That is, a warrant of arrest cannot be executed in a court room while the court is in sitting. 2. A warrant of arrest cannot be executed in any legislative house while the house is in session, except with the consent of the President of the Senate or the Speaker of the House, as the case may be. A warrant of arrest cannot be executed in any embassy or high commission of foreign nation because of diplomatic immunity. What if the warrant of arrest is to be executed outside the jurisdiction, where a warrant of arrest is issued in one state and to be executed in another state? It has some certain procedure. The investigating officer must ensure that the warrant is in duplicate copy. The warrant will be taken to the appropriate magistrate in the state where the suspect resides or is found. Example, the warrant of arrest is issued here in Adamawa State and to be executed in Gombe State, Nigeria. The investigating officer need to take the warrant to the magistrate, who will going to endorse the warrant after he satisfies himself that the warrant is issued by the magistrate or the judge, where the name appears on the process and that the alleged offense is known to the law in the state of issue. The endorsement of the warrant is sufficient authority to the police officer to execute the warrant by arresting the named person and briefing him to the endorsing magistrate. Upon the defendant is brought to the magistrate who endorsed to the warrant, the magistrate may do any of the following. 1. By the warrant under his hand, order the person arrested to be returned to the state that issued the warrant, and for this purpose be delivered to the officer who broke the warrant. Where the offense for which the person is suspected of is bailable, the magistrate admits such a person to bail upon condition as it deemed fit. And there is arrest without warrant. Arrest without warrant is an arrest of an individual without the use of the arrest warrant. Arrest by a police officer without warrant. A police officer can arrest also without warrant any person who obstructs a police officer while in the execution of his lawful duty or has escaped or attempted to escape from lawful custody. Another instances where a police officer can conduct an arrest without warrant is where any person whose possession anything is found which may reasonably be suspected to be stolen property, or who may reasonably be suspected of having committed an offense with reference to the thing found in his possession. Another instances where a police officer can arrest without warrant is a police officer can arrest any person who is suspect or on reasonable grounds of being a deserter from any of the armed forces of Nigeria. A police officer also can arrest without warrant any person whom he suspects on reasonable ground of having been involved in an act committed at a place outside Nigeria which, if committed in Nigeria, will have been punished as an offense, and for which he is, under any law enforced in Nigeria, liable to be apprehended and detained in Nigeria. A police officer also can arrest without warrant any person who he has reasonably cause to believe a warrant of arrest has been issued by a court of competent jurisdiction in Nigeria. And a police officer can arrest without warrant also any person who warrant has been issued whom he is directed to arrest by a judge, magistrate, justice of peace, or superior police officer. Arrest by a special person. Special prosecutors are simply statutory agencies saddled with powers to make certain arrests in the course of carrying out their duties. For example, the Director of State Security Service, that is SSS, National Drug Law Enforcement Agency, that is NDLA, Economic and Financial Crime Commission, that is EFCC, and others. Each of the special prosecutor is empowered by the law establishing it. Generally, the power includes to arrest and investigate any person found violating such act. In an arrest, there is what we call arrest in lieu of a suspect. Section 36 of the Police Act 2020 provides that a person shall not be arrested in place of a suspect. This is sometimes common in Nigeria, especially in rural areas, where as a result of ignorance of the indigents of what the law is, allow security officers to have them arrested in place of their relative or blood relation being suspected of a crime. In the case of Uzo Ship vs. Nigerian Army 2002, 5 Nigerian Weekly Law Report, Part 761, page 188. In this case, the plaintiff was arrested and detained in place of his brother, who was the actual suspect in crime. The court held that arresting and detaining a person in place of another is unlawful and violates the constitutional right to personal liberty under Section 35 of the 1999 Constitution as amended. In that case, the plaintiff was awarded damages for the unlawful arrest. The court, in the case of Madaki and others versus GTV and others, 2020 LPELR 57419, Court of Appeal, affirmed the position I have mentioned, where it was held that we have appreciated this situation several times, that it is wrong to arrest a wife or husband in lieu of the other, or father, mother, to force the child that is suspect to come to the police or law enforcement agency. In the case of Jim Jagger versus COP River State and others, 2021 LPLER. In this case, the Supreme Court of Nigeria ordered the sum of 2 million naira to be paid to an appellant who was unlawfully arrested and detained on behalf of his brother or relative. From the authority I listed, it is glaring that arrest in lieu is prohibited in Nigeria. This practice amounts to a breach of fundamental human rights, and the same give the right to the person so arrested to seek compensation at the court of competent jurisdiction.